Friends, I am Shivashish.Advocate. I am a practicing advocate. Today I would be discussing the judgment of Honorable Delhi High Court in the case of Bharti Airtel Ltd. Honorable Delhi High Court has ruled that rectification of GSTR-3B can be done in the same month to which error or omission relates. Illustratively, if we can discuss the significance of this judgment, let's say a registered person has a taxable turnover of ₹1,000 each month. In the month of July 2017, when GST was introduced, ₹1,000 turnover was reported as ₹1 lakh. And now, the department issued a circular which provided that rectification of this ₹1 lakh which is reported can be done in the subsequent months. However, as I said that the registered person has the turnover of ₹1,000 per month, and the rectification will take around 99 more months to rectify this completely, because the turnover has been reported 100 times more than the turnover which was originally there. This will involve interest implication, and whether or not the taxable person would be carrying on business in the future is again a question. Therefore, this circular was challenged, and Delhi High Court read down this circular para 4, which stated that rectification can be done in the subsequent month. Delhi High Court ruled that the rectification can be done in this same month. Let's discuss the facts and the judgment of this case. Thank you. Facts. Writ petition under Article 226 of the Constitution of India was filed by the petitioner, that is Bharti Airtel Ltd. It challenged that para 4 of the circular number 26, which basically provides that rectification of any mistake or omission in GSTR-3B can be done in the month in which these mistakes are noticed, and not in the month to which these mistakes or errors relates. It was challenged that these provisions, this circular paragraph 4, is ultra vires the provisions of section 37 to 43 of the CGST Act. It was challenged on the ground that section 37 to 43 of the CGST Act not only provides for filing, it also provides for verification of the returns before filing. So, illustratively, if a registered person has filed GSTR-1, the data of GSTR-1 is auto-populated in the GSTR-2A of the recipient. Before input tax credit is taken by the recipient, he validates that input tax credit basis the details which are available in GSTR-2A, and after validation he files GSTR-2. Thereby, it implies that the errors which can be committed by the recipient are corrected in the same month, because it receives the auto-populated details of the supplier, basis which it can validate the data which needs to be filed before the authority of input tax credit. GSTR-2A reflects the details of input tax credit, and before filing it can validate that data and file GSTR-2A thereafter. However, since the system was never been introduced, a standalone return was introduced in form GSTR-3B. It was stated that GSTR-3B is a standalone return. It doesn't provide a mechanism of validation as is provided under section 37 to 43 of the CGST Act. Since I stated that 1 becomes 2A of the recipient, however, in 3B, ITC figures are standalone figures and these are not validated. Because of this, in the month of July to September 2017, when GSTR-2A was not operational, petitioner paid excess tax to the tune of 923 crores of rupees. It was paid due to the fact that ITC, which was supposed to be taken in GSTR-3B, was never being taken in the month of July to September, because the petitioner was not having the data of input tax credit. First, it was not having the data of input tax credit because of the reason that GSTR-2A was not available, and another reason that the petitioner was under a centralized scheme of registration when the service tax was in force. However, after GST, around more than 35 registrations were supposed to be taken by petitioner. Because of this reason, it was not able to get the data from decentralized offices where the GST registration was taken, and leading to this that ITC, or even on self-assessment basis, was not being taken by the recipient. That is Bharti Airtel, that is petitioner in this case. This error occasioned due to non-operation of GSTR 2A, 2 and 3. Had it been operationalized, it would have been corrected in GSTR 2A of that month itself as against GSTR 3B, where it can be rectified in the month where error are noticed. No refund, further this is elevated by the fact that no refund is allowed even in case of excess payment of tax, because department doesn't say it to be excess payment of tax. This is legitimate payment of tax. However, payment of tax has been made by way of cash and not by using ITC. Therefore, refund was even not allowed to the petitioner. However, paragraph 4 or circular number 26 provides that if ITC has not been taken, it can be taken in the subsequent month's return. However, petitioner stated that now my tax liability has been reduced substantially in the subsequent months. Therefore, even if I take the ITC in the subsequent months, it cannot be utilized fully. Therefore, a direction was sought from the High Court that a direction be given to the department to please refund the excess payment of tax which has been done through cash ledger, and ITC can be verified before that refund. Observations and ratios. CGST Act provides for verification, validation, modification, deletion of the information in GST return of the same month. So let us say had been the system of GSTR 123 been operational, the recipient, that is Bharti Airtel, would not have committed this mistake, because the errors could have been rectified in the July month itself when the data reflected in GSTR 2A would have been validated with the data which is to be captured in GSTR 2. However, GSTR 3B was introduced, which doesn't have inbuilt checks and balances to ensure that the data is verified and validated. Therefore, Delhi High Court read down circular number 26 to the extent it stated that rectification of GSTR 3B in respect of the period in which error has been occurred cannot be done. Delhi High Court read down this on the ground that it is ultra-virus provisions of section 37 to 43 of the CGST Act, because these sections provide that rectification of the errors can be done in the same month and there is no reason that it should be delayed, rectification should be delayed. Because in the case of petitioner, it is leading to the blockage of ITC even though taxes has been paid by way of cash, and that ITC now cannot be utilized in the subsequent months because the tariff has been reduced, and because of that they say that it cannot be utilized. Subordinate legislation must conform to the statute and cannot whittle down the benefits. The benefit which is provided under this provision is that it can be verified, validated before submission. However, this has been whittled out by the circular by stating that GSTR-3B is a return which is to be manually filed, which doesn't have inbuilt checks and balances to ensure that it is verified and validated. Reliance was placed on the judgment of Honorable Supreme Court in the case of Commissioner of Central Excise, Bolpur versus Ratan Melting and Wire Industries, in which it was stated that it is for the court to declare what the particular provision of the statute says, and it is not for the executive. The executive in this case stated that rectification of GSTR 3B can be done in the month in which errors are noticed. However, the provisions state that the rectification can be done in the same month basis the details which are received from the supplier. There is no reason to deny the benefits to the recipient, that is Bharti Airtel in this case, and therefore it was stated that para 4 has to be read down as ultra-virus the provisions of section 37 to 43 of the CGST Act. Rectification of GSTR 3B was allowed in the same month in which the errors were committed. In this case, July to September 2017 return needs to be rectified, and they will be rectified. The rectification implies that ITC would be availed in these returns, and the excess cash which has been deposited would be either credited back to the cash ledger or would be refunded back to the recipient, that is Bharti Airtel. Now, having discussed this judgment, what is the way forward for other taxable persons? The way forward of other taxable persons, as I discussed in the initial part of the illustration, that they can approach the writ court or they can approach the department. If the department rejects, they can sort for a direction from the writ court, that is High Court, that GSTR-3B rectification should be allowed. Even the possibility of getting interest from the department can also be explored, because of the fact that the funds are lying with the department. The funds which are with me, that is ITC, in this case has not been utilized and cannot be utilized. The department has taken my cash. The cash I would have utilized or placed somewhere else, and basis that I would have earned the interest. These proceedings or these thoughts can be also be discussed with your consultant, with your advocate, as the case may be. With this, I close my presentation. I am